So we move on to the seventh method of acquiring ownership. And this method is called treasure finding. So what do you do when you find treasure? First of all, what is treasure? So treasure is something that is movable, something of high value, and something that has been hidden for so long a time that it is almost impossible to find the original owner thereof. So that's the treasure. It has to have these three components: movable, high value, and hidden for so long that it is almost impossible to find out who the original owner was. So what do you do? How do you acquire ownership of this treasure? Well, the first thing that you need to know is that you need to report your finding to the authorities. So basically, you need to tell the municipality, oh, I found a box of gold in my garden. And then you immediately become the owner. So you don't have to wait a year or anything. You simply have to report it, but you also immediately become the owner. So what happens in a situation where you were a farmer and you had borrowed the land from someone else? So your crops are on the land, but the farm actually belongs to someone whom you are renting it from. In that case, what happens is that you, as the finder, will be entitled to 50% of the treasure, and the owner of the property will be entitled to the other 50% of the treasure. Obviously, if the property is yours, then you are entitled to 100% of the treasure. So this is a method of acquisition which is called treasure finding. Acquisition of ownership by prescription, method number 8. Prescription is basically when you wait for a certain number of years and then a piece of property becomes yours either in good faith or in bad faith. So I'll give you a few seconds to read what is written in this slide. Okay, so basically, if you continuously possess an object which is movable for 3 years in good faith, then you become the owner of that thing by prescription. Earlier, I made an example of when you found a pencil at school and you took it to the reception, and the receptionist asked you to keep the pencil until the owner came forward. Now, if the owner does not come forward for 3 years, because you are a possessor in good faith of a movable thing, then after 3 years, that pencil becomes yours. Even if the original owner of the pen comes to claim his pen in the 4th year, that will be too late. The pencil will officially be yours as the owner after 3 years. Now, if you're possessing immovable property in good faith, then you become the owner of that immovable property after 10 years. The example I have here is a fence. So this is a fence dividing 2 homes, the home with the hedge and the home with the grass. So let's say the owner of this home with the grass actually does not own, let's say 500 meters, not 500 meters, a meter. Let's say he does not own 1 meter of the land that he's actually put a fence on. So 1 meter of this land, so from this fence into his property, 1 meter from the fence into his property actually belongs to the neighbor. So it belongs to the guy who owns the hedge. But both neighbors do not know this. So both neighbors think that the fence is in the right position. In this case, the guy who put the fence and took away the 1 meter of land from the neighbor is acting in good faith. So in that case, after 10 years of having his fence over there, he becomes the owner of the 1 meter of land. So after 10 years, in good faith, as a possessor in good faith, he becomes the owner of the 1 meter of land which he was already using. But if this guy knew that the 1 meter of land did not belong to him, but he simply put a fence there to trick the owner, then he is a possessor in bad faith. In that case, he has to wait 20 years before he legally becomes an owner. So we call this acquisition of ownership by prescription. Remember, he has to be in possession of this property continuously for the duration of those years. So if, for example, in the case where the guy who stole the 1 meter did it in bad faith, so he's a possessor in bad faith, if in the 18th year or the 19th year the neighbor came to claim, lays a claim on the 1 meter of land, so he discovers that 1 meter of land is his, then in that case the prescription will stop. So the prescription has to be uninterrupted for those years. Let me make another example. Okay, so another example is with 3 years in good faith of a movable object, so where you had a pencil. If the owner of the pencil claimed his pencil back after 1 year after you found it, and then he did not take the steps to actually find you, that means that we start counting 3 years afresh. So even though you had counted 1 year and you're only left with 2 more years to become owner of the pencil, because the owner of the pencil claimed the pencil after the 1 year, the prescription stopped. And then it started again when he stopped, the owner of the pencil stopped claiming it. So you start counting again a fresh 3 years after that. So it has to be continuous. It has to be uninterrupted possession in order for you to acquire ownership of the thing through prescription. The 9th method of acquiring ownership is through expropriation. So expropriation is basically when the government takes possession of your property. The government therefore becomes the owner of your property. Normally they do it for something that has a public use, and in this example here, the government wanted to build a road. So before this road was built, there were houses here. So the government had to ask the owners of these houses to sell their houses to the government. Well, it's not really selling, because the government has to demolish these houses in order to build a road. So the government has to ask all these people who had houses here to leave their houses, and then the government can build a road. So obviously this guy here refused, and so yeah, that's called expropriation, when the government takes ownership of your property for a public use. Of course, they won't just take it away and leave you like that, but normally, or always, they have to give you compensation. So compensation means they have to give you money or a new house. So that's expropriation. Expropriation, when the government becomes the owner of your property, you take it away from you, normally for a public purpose, like building a bridge, building a road, building a railway line, building a dam, and in exchange they give you some money. The 10th method of acquiring ownership is through community of property. So community of property just means when you get married to someone under the regime of community of property, then half that person's estate becomes yours and half of yours becomes that person's. So basically your estates come together and they merge. So in case you divorce, then the other partner will take half of the estate and the other partner will take half of the estate. But for example, if one of the partners dies, then the other partner will take the entire estate. Assuming, of course, that they did not have children. Now, the 11th method for acquiring ownership is through transfer. So, transfer is the most obvious method of acquiring ownership of a property. It's basically when you buy stuff, but not only when you buy stuff, but also when stuff is given to you as a gift or when you exchange property between two owners. So there are 3 requirements for transfer. So the first is you need a valid title. A valid title is the legal basis for transfer. So the examples are the ones I just mentioned. A sales agreement, a gift, or an exchange agreement. So when someone gives you a gift and you accept the gift, that is called a valid title. Or when you buy a bottle of water from the Albert Heijn, that is a sales agreement, and that is also a valid title. Or when you exchange your old cell phone for a new iPad, that is an exchange agreement, and that is indeed a valid title. That's the first requirement. The second requirement of transfer is that the person who transfers the property must have the authority to transfer that property. What does that mean? That means that the owner of a thing has authority to sell his thing. But for example, if you have a car and you take your car to the dealership and you ask the dealer to sell your car on your behalf, the dealer also does have authority to sell your car because you gave him that authority to sell your car. So authority is the right, the legal right to be able to transfer property. However, if a thief sells a piece of property that's not his, then the thief has no authority to sell that thing because he has no legal right to sell that thing. So in that case, the transfer would fail. The third requirement of transfer is delivery. So basically, after you buy something, it has to be delivered to you. Normally, if you, with Albert Heijn example, if you buy water from the Albert Heijn, they hand it to you at the counter after you pay for it. In that case, the water is delivered to you through a factual transfer. So they actually give you the water. That's delivery. So I repeat, transfer requires 3 things: a valid title, authority, and delivery. So the point at which these 3 things become fully realized in a transaction, then we say that from that point on, the transfer is complete. Now, with delivery, as you can see here, there are 6 methods of delivery. Yes, that is a lot indeed. And yes, you have to remember all 6 methods of delivery for the exam. So I will start these 6 methods of delivery in the 3rd video. But for now, remember that transfer requires a valid title, so a sales agreement, a gift, or an exchange agreement. It requires authority, so the person transferring the property must have the right, the legal right to dispose or transfer that property. And delivery, meaning the person who is acquiring ownership of the thing should have the thing delivered to him or given to him. These are the 3 requirements of transfer. And now we're going to discuss the methods of delivery, which is the 3rd requirement of transfer, in the next video.